the environment and the limitations inherent in the very mechanism of reparation of this type of damage. Many tales have been told in these proceedings about the nature of due diligence and the content of GHG emissions and associated harms. One is reminded of the parable of the blind men, who upon first encountering different parts of an elephant came to vastly different and erroneous conclusions about what it looks like. Likewise, a blinkered vantage point on due diligence obscures the reality of what it must look like in the context of climate change. Contrary to the assertions of some participants, the obligation of due diligence is by no means just procedural, requiring only a box-ticking exercise, nor is due diligence merely a subjective assessment dependent on the eye of the beholder. In its COSIS advisory opinion, ITLO steered clear of such untenable assertions. Consistent with the court's jurisprudence on transboundary harm, ITLO's placed the best available science reflected in IPCC reports at the core of its legal analysis. It determined that the standard of due diligence under UNCLOS Part 12 is, quote, stringent, requiring states to, quote, deploy adequate means to exercise best possible efforts to do the utmost. Mr. President, honorable members of the court, the only logical conclusion to be reached is that the standard of due diligence in respect of climate change is exceedingly stringent. We are dealing today not with a low risk of small harm. We are dealing with a near certain risk of catastrophic harm posed by each additional increment of warming, as the IPCC and in turn ITLOS have observed. Further, the science is clear as to the causal link between GHG emissions and the significant harm to the environment. This is a complete answer to the argument of some participants that the prevention obligation does not apply to GHG emissions. And the science is also clear that the NDC commitments of states are clearly inadequate to prevent environmental harm, such that, again, contrary to what some have suggested, the Paris Agreement simply cannot be the exclusive embodiment of the prevention principle. This takes me to my second point, that the best available science also provides the specific content of the relevant obligations. The court, like other jurisdictions, has looked to the science when assessing the necessity of measures. Taking the objective science is key to measures ranging from conservation and management of natural and ecological resources to preventing irreversible environmental damage. Likewise, as ITLOS affirmed, quote, necessary measures with respect to GHG emissions in UNCLOS Part 12 include those, quote, which are indispensable to prevent, reduce, and control marine pollution, as well as other measures which make it possible to achieve that objective. Again, this is an objective assessment, and the science is determinative. To make the role of science concrete in this context, let's consider what the world looks like beyond 1.5 degrees. The IPCC has assessed that warming beyond that threshold increases from moderate to high the risk of catastrophic harm to terrestrial, freshwater, coastal, and marine ecosystems. This would result in significant harm to human populations, including, for example, food insecurity due to marine impacts for nearly 1/5 of the world's population and half of SIDS populations, and the displacement of potentially hundreds of millions of people. Measures that fail to provide a means of avoiding these outcomes simply cannot be considered to fulfill obligations to take, quote, necessary action. COSIS thus submits that diligent measures to prevent negative climate change impacts must necessarily include mitigation in line with the IPCC's specific emissions pathway. According to the IPCC, to have even a 50% chance of staying within the 1.5 degree Celsius threshold, states must reduce GHG emissions as measured against 2019 levels by at least 43% by 2030, 60% by 2035, 69% by 2040, and 84% by 2050. According to UNEP, unless states rapidly and deeply reduce their emissions, quote, it will become impossible to get on a pathway that limits global warming to 1.5 degrees Celsius with no or limited overshoot, end quote. There can be no doubt then that at a minimum, quote, transitioning away, end quote, from fossil fuels as states recognized at COP28 is required. To put it bluntly, when the best available science tells us that drastically cutting GHG emissions is an imperative, then what is diligent and necessary speaks for itself. Mr. President, honorable members of the court, COSIS invites the court to follow the settled jurisprudence and affirm that in the face of the objective facts and science, state obligations to exercise due diligence must be robust and specific. Thank you very much for your kind attention. I kindly request that the court call Professor Akhavan to the podium.
I thank Ms. Amir Farr. I now give the floor to Professor Payam Akhavan.
Mr. President, distinguished members of the court, it is a privilege to appear on behalf of the 9 member states of COSIS. My remarks will focus on your unique role as the principal judicial organ of the UN in the harmonization of international law. You have now heard from numerous participants. There is widespread consensus on the importance of harmonization. A handful of high-emitting states, however, have attempted to rehabilitate the defunct lex specialis theory. Others have promoted fragmentation under the guise of systemic integration. I shall briefly address 4 of the most salient points. First, the argument that the UN climate change regime limits application of international law finds no support in legal logic or reasoning. There have been multiple variations on this theme, yet not a single state can point to an actual normative conflict between the procedural obligations under the Paris Agreement and the substantive obligations under the principles of transboundary harm and human rights. As noted by the former president of the court, Gilbert Guillaume, in 2016, si les États lors de la
Though at COP21 states set their common objectives, the will thus expressed must now be turned into legal rules.
The COSIS advisory opinion, ITLOS emphasized the importance of coordination and harmonization between the Convention and external rules. It concluded that the Paris Agreement does not modify or limit the obligations under the Convention. It held further that the Paris Agreement is not lex specialis to the Convention, and that even if it was, it should be applied in such a way as not to frustrate the very goal of the Convention. Yet that is exactly what some states have attempted to do in these proceedings, to frustrate the very goal of protecting the environment and human rights. Not a single state has explained how self-judging NDCs under the Paris Agreement that have already resulted in significant harm could possibly be reconciled with due diligence obligations. As Ms. Amifar noted, the unclosed Part 12 obligations to protect the marine environment are largely customary international law. There is no reason why the court should adopt a lower standard in respect of the environment as a whole. Second, the argument that state responsibility does not apply to climate change because it is too abstract or diffuse is wholly without merit. This is not even a lex specialis argument. It is a non-liquid argument. It would result in a dystopian world with a sacrifice zone for the climate vulnerable states and a zone of impunity for the major polluters. That cannot be right. The court has noted in advisory proceedings that a rule of international law does not operate in a vacuum. The scientific evidence must inform this opinion, and it leaves no doubt as to the question of causation. At the same time, the court need only make general and not detailed findings on attribution. This is not a contentious proceeding. The COSIS request to ITLOS was focused on primary rather than secondary obligations. Nonetheless, the tribunal drew the obvious conclusion that if a state fails to take all necessary measures to prevent, reduce and control marine pollution from anthropogenic GHG emissions, then international responsibility would be engaged for that state. Since Part D of the question in this proceeding expressly refers to legal consequences, the court should go further than ITLOS. There is obviously the obligation of compensation for injury already caused, whether through measures such as debt relief or the loss and damage fund. But the court should also consider the obligations of cessation and non-repetition. In this regard, the 2023 IPCC report concluded with high confidence that estimates of future CO2 emissions from existing fossil fuel infrastructures without additional abatement already exceed the remaining carbon budget for limiting warming to 1.5 degrees Celsius. In this light, several COSIS members have endorsed the Fossil Fuel Non-Proliferation Treaty Initiative. In 2023, at COP28 in Dubai, state parties agreed at a minimum on transitioning away from fossil fuels in energy systems. Building on this consensus, the court could provide valuable guidance by clarifying that the obligations of cessation and non-repetition necessarily require a deep, rapid and sustained transition away from fossil fuels. This must be consistent, furthermore, with the emissions pathways discussed by Ms. Amirfar. Given the imminent risk of catastrophic harm, the temporal dimension is crucial. Third, there is a pressing need for the court, as the principal judicial organ of the UN, to harmonize the emerging jurisprudence on climate change. Beyond ITLOS, this includes regional human rights courts as well as UN human rights expert treaty bodies. This would ensure the unification and coherence of international law. A good illustration is the 2021 decision of the Committee on the Rights of the Child in Sachi versus Argentina. It found, based on the 2017 Inter-American Court of Human Rights advisory opinion on the environment and human rights, that when transboundary harm occurs, children are under the jurisdiction of the state on whose territory the emissions originated. There is no reason for this court to adopt a contrary view. As noted in Bosnia versus Serbia, the court attaches the utmost importance to the factual and legal findings made by other jurisdictions within their specific purview, referring in that case to the ICTY. The findings of both ITLOS in respect of UNCLOS and the regional human rights courts and UN treaty bodies in respect of relevant human rights instruments are unquestionably within their specific purview. They must be accorded significant weight. Fourth and finally, the court should also harmonize the sources of international law. While much has been said about conventional and customary international law, general principles recognized by nations should also be considered. Several small island states in the Pacific and other national legal systems apply indigenous customary law, as some statements have noted. The normative insights of these traditions are worthy of the court's attention in the spirit of a pluralistic international law. Indigenous law is a reminder for all peoples that whether we invoke ancient wisdom or modern science, we have no choice but to conform to the greater laws of the natural world. Mr. President, this is not a radical interpretation of international law. It is common sense. States have consented, as they must, to science-based conclusions to protect the environment. Presumably, states have not consented to mass extinction and the collapse of civilization. This is not climate alarmism. It is the stark reality of a temperature increase of 3 degrees Celsius by the year 2100. That is where the current NDCs will take us. The small island states are the canary in the coal mine of climate catastrophe. The major polluters should heed their warning before it is too late, because they too will pay a heavy price. Mr. President, distinguished members of the Court, the questions before you are of exceptional significance. Some 30 years ago, the Court issued the Nuclear Weapons Advisory Opinion. It too was on a question of exceptional gravity. But to put matters in perspective, because of unabated GHG emissions, today the oceans absorb the energy equivalent of 7 Hiroshima bombs every second. You heard on the opening day the words of youth leader Cynthia Honyuhi from the Solomon Islands. Land is our mother, she reminded us, a living, timeless plane where generations past, present, and future converge, interconnected and sustained in an unbroken cycle of life. How will future generations look back at these proceedings? This is a crucial moment for the very idea of international law. Narrow state-centric conceptions must give way to the reality of an inextricably interdependent planetary civilization. The climate system does not recognize the artificial boundaries that we have created in our political imagination. There is one Earth, one humankind, and one supreme law that none can escape, which is to live in harmony with nature or to perish. Mr. President, distinguished members of the Court, I thank you for your kind attention. This concludes the pleadings of COSIS.
I thank the representatives of the Commission of Small Island States on Climate Change and International Law for their presentation. I now invite the delegation of the Pacific community to address the Court, and I call Mr. Stuart Minchin to the podium.
Honourable President, Madam Vice President and members of the Court, my name is Dr. Stuart Minchin, and I'm privileged to serve as the Director General of the Pacific Community, or SPC as we are known. SPC is the principal scientific and technical organisation of the Pacific region. It's also the oldest and largest of the region's intergovernmental organisations, representing the collective scientific and technical capacity of 22 Pacific Island countries. Technical and scientific capabilities provide a solid foundation to inform the questions before the Court. SPC's role as an accredited entity to the largest climate financing mechanism of the UNFCCC and Paris Agreement also provides valuable experience in understanding the realities of the failed promises of climate finance as obligated by states under these frameworks and its subsequent impact on the Pacific communities. Pacific leaders aptly describe our region as the blue Pacific continent. It's 98% ocean. It contains 30% of the world's exclusive economic zones and over 60% of the world's tuna stocks. Half of the Pacific population lives within 5 kilometres of the coastline, which highlights the consequence of extreme sea level events to the security of the region. Mr. President, I am a scientist and I deal primarily in facts and evidence. The science is clear. Climate change is already causing existential impacts to the peoples and communities of our vast Pacific region, and meaningful action is required to reduce its impacts as a matter of urgency. Okay, no problem. Thank you. The IPCC and the latest global stocktake outcomes confirm that the collective ambitions of states remain woefully inadequate to keep global warming below 1.5 degrees, which is a non-negotiable line for planetary health and Pacific habitability. Instead, we are on a pathway to 3 degrees by the end of this century. Despite the clear science, finance flows to fossil fuels continue to outstrip the transition and scale-up of renewables in every region of the world. The IPCC and SBC's science and knowledge from our Blue Pacific could not have been more clear. What we do within this decade will have consequences for thousands of years. Given this, our oral submission will be presented by 3 speakers and will focus on 4 key elements. The first is the unique impacts of climate change in the Pacific, which demonstrate the reality that the rest of our planet will face if the action does not meet the urgency required. The second issue will be examples of loss and damage, both economic and non-economic. The third issue will be the implications of slow and onerous climate finance flows not meeting the necessary demand. And the fourth will be focus on human rights and intergenerational equity. For the unique impacts of climate change in the Pacific, I'll expand on 2 critical examples: ocean warming on the region's blue economy, with a particular focus on fish stocks, and sea level rise and its impacts on habitability. Climate change threatens to permanently degrade and destabilise coral reefs, ocean ecosystems, and the key species that we are dependent upon. Given the time, I will focus only on the tuna fishery and its projected displacement because of global warming. The Western and Central Pacific Ocean is home to over 60% of the world's tuna stocks that continue to be sustainably managed by Pacific countries, and it supplies 1/2 of the global tuna supply. 9 Pacific SIDS derive an average of between 10 and 84% of all government revenue from tuna-specific licensing fees. It employs about 6 to 8% of the labour force and an increasing percentage of women. The science of Pacific tuna and the projected climate impacts are predicted to alter the migratory patterns of tuna, moving them eastward into the high seas areas. The latest modelling and economic analysis indicate that 20% of the combined tuna catch currently harvested in Pacific EEZ waters will shift to the high seas by 2050 if emissions continue to rise. This represents $90 million per annum in lost access revenue for all Pacific SIDS combined by 2050, and losses of up to 10 to 15% of total government revenue for a number of countries. It also undermines the health of what is today the only sustainably managed global tuna stock and places pressure on the food security of our Pacific communities. The second example I wish to highlight is the observed and projected impacts of sea level rise on habitability and the resulting forced migration and displacement, particularly for the most vulnerable communities and peoples of the Pacific. Mr. President, honourable members of the Court, you have seen and heard from the Republic of the Marshall Islands and Tuvalu on the impact that sea level rise is already having on their communities in our region, and projections of future impact on intensity and frequency of disastrous sea level rise events. This science and work have been co-led by SPC, but for the purpose of brevity, I will not further emphasise this science. However, I would like to refer you to the reference by the Republic of the Marshall Islands to the vulnerability of the Runit Dome, as seen on the screen. This nuclear waste site is part of the region's nuclear legacy. Climate change and resulting coastal erosion could undermine the integrity of this sealed waste site, which threatens to impact not only the Marshall Islands but also our Blue Pacific Ocean. Through SPC's Digital Earth Pacific tool, we can measure the changes in every coastline in the Pacific over time from satellite. And as you can see from this diagram, coastal erosion around the Runit Dome has progressed by over 12.4 metres over the past 2 decades. This leaves only 10 metres of erosion to go before Pacific Ocean waters will hit the very edge of this nuclear waste site at every high tide. At current rates, this is expected to occur within 20 years if urgent action is not taken. This is just one example among thousands where small changes in sea level will have profound implications for infrastructure, risks, and important community and cultural assets throughout the Pacific. This challenge is particularly acute for the lowest lying atolls, where their entire population live within a kilometre of the ocean, and the average elevation above sea level of the islands is usually just 1.5 metres. Honourable members of the court, this height above sea level is less than the height of the bench that you sit on today. As scientists, we have had to learn to be systems thinkers. We know the world does not work in independent component parts, but as an interconnected system. We have learned over the last centuries not to ignore the interconnected nature of the ecosystems we study, or we make mistakes that can be catastrophic. However, it seems that in some cases the law does not currently operate like this. Rather, the law appears to adopt a reductionist approach to the natural environment, having separate legal frameworks covering different components of the natural ecosystem, and this leaves open the prospect of big issues falling through the cracks. For example, you will note that both of our examples of critical climate change impact are based around the centrality of the climate-ocean nexus, and yet, despite years of trying, because of the current legal constructs, oceans are still effectively excluded from the UNFCCC framework. Standing here as a scientist in a courtroom full of lawyers, from one honourable profession to another, the legal community needs to address climate change realities. The natural ecosystem does not have arbitrary boundaries, and in the 21st century, the legal ecosystem of international law needs to reflect this. There must be an alignment between the interconnected science and harmonised international law that does not allow countries and people to fall through the legal cracks. This case is a wonderful opportunity to show the way. Honourable members of the court, the science is clear. Projected emissions from existing fossil fuel infrastructure alone will exceed the remaining carbon budget to limit warming to 1.5 degrees C. The science must inform our action, including in the law. We have the solutions, but we are not moving fast enough, and that is where the outcomes of this case matter most. In answering the question before you, I want to keep this last point very simple. Under no scientific scenarios can we continue to pursue a future underpinned by fossil fuels and still expect to meet the goals of the Paris Agreement. We need to act now to ensure the livelihoods and self-determination of Pacific people and cultures are protected for future generations. Mr. President, thank you, and I kindly ask you to call Ms. Coral Passisi, our Director of Climate Change at SPC. She is also a scientist, and as a daughter of the Pacific, has inherited the traditional knowledge and practice of her forefathers and mothers that informs her understanding of how climate change is affecting our countries and communities. Thank you.
I thank Mr. Seward Minchin, and I'll give the floor to Ms. Coral Passisi. You have the floor.
Thank you, Mr. President, Madam Vice President, and honourable members of the court. It is a great honour to speak to you today on this critically important question. My statement will focus on two key elements. Firstly, what loss and damage already looks like in our region, and secondly, the elusivity of promised climate finance for the most vulnerable. The loss and damage already experienced, together with the associated impacts on culture, traditional practice and knowledge, have both extreme economic and non-economic implications. Let me share with you a personal experience based on a Category 5 cyclone, Cyclone Heta, which occurred in 2004 and left a trail of destruction across the Pacific, across 5 island countries. I will focus on the experience of Niue, the only Pacific SIDS who was unable to present at these oral proceedings, and which I am a proud Indigenous daughter of. Niue is a large raised coral atoll with cliffs, terraced and standing around 20, 38 and 68 metres above sea level. In this video, you will see wave height at close to 10 metres hitting our only port, 6 hours before the height of the storm, which at its peak reached about 40 metres on the western side of our island. And for context, that would be roughly over twice the height of this courtroom. What you are seeing in this second video is the aftermath of that wave inundation on what was one of the most populated stretches of critical infrastructure and homes in Niue's capital of Alofi. It is also where our main tourism accommodation, our only hospital, Justice Department and courthouse and National Museum stood just 12 hours prior. It was also where both my brothers' homes were washed away and countless other families, and where the loss of tragic life occurred. The economic damages sustained by Cyclone Heta in Niue alone equated to 5 times the GDP of our country. This was equivalent to 200 years' worth of exports at that time. This underscores both the magnitude of economic loss and damage and also the limited ability of small island states like Niue to recover and respond. It also washed away our only museum, Huanaki, and over 90% of all our cultural artefacts along with it. This is an unimaginable and irreparable and irreplaceable non-economic loss, one that cannot be remedied or restored, one that has robbed our children of their future inherent rights of traditional knowledge and cultural identity, and which has left scars of trauma that run as deeply as the scours left on the bare cliffs of Niue some 20 years later. This will permeate for many generations to come, and is indicative of the trail of loss and damage that is left in the wake of global inaction. Inaction in mitigation and inaction in providing the necessary finances for the most vulnerable and least able to cope. And as a segue into my second point, let me share with you Niue's experience in seeking some remedial support to address the loss and damage and rebuild from the ruins of this cyclone. On seeking assistance from the funding mechanisms of the Convention and Paris Agreement to rebuild critical infrastructure, such as the museum and hospital, to higher grounds, they were advised that such costs could not be covered by climate finance, as these actions were considered response, recovery, or loss and damage, which does not fall within the remit of adaptation. Which brings me firmly to the second issue I will highlight: the injustice faced by SIDS in access to adequate, timely finance, as the most vulnerable and least capacitated to respond, who, as we have repeatedly heard, are also the least contributing to greenhouse gas emissions. A key first distinction to make is that, as a continuation of the responsibility under Article 4 of the UNFCCC, Article 9 is the most relevant article of the Paris Agreement, obligating developed countries to provide the required finance to developing countries to address climate change. Article 2(1)(c) speaks to climate-consistent finance flows, but this is distinctively different and should not be conflated. Whilst both articles are clearly complementary, climate-compatible finance flows under Article 2(1)(c) should not be considered as a substitute for what is an obligation of developed countries under Article 9. This is to provide new and additional finance for the new and additional costs as a result of climate change, particularly for the most vulnerable. In practice, however, Article 2(1)(c) has been used to muddle and often double count traditional finance flows, including aid, with states having delivered their obligations under Article 9. There are very few developed countries who clearly distinguish between their pledges of commitment of climate finance under Article 9 and Article 2(1)(c). In practical terms, instead of climate finance pledges being new and additional resources to cope with climate change challenges, a significant portion of these resources and pledges are actually just relabeled traditional aid. This has caused considerable frustration and unmet expectations for all developing countries, and particularly SIDS in our region. SIDS have spent considerable capacity to ready themselves for promised increased climate finance under Article 9, only to see the failed realisation of these promises in real terms. As the Prime Minister of Tonga spoke to at COP29, and I quote, "Without this promised climate finance, as leaders we find ourselves having to make the impossible decision between using what little resources we have to either fortify existing critical infrastructure or continuing to develop our country. We do not have the finance for both." Furthermore, Articles 9.4 and 9.9 are supposed to guarantee that in the discharge of promised climate finance the promised climate finance, that it prioritises the particularly vulnerable and capacity constrained, being small island developing states and LDCs. In reality, neither of these obligations have been met. The achievement of the 16-year-old global promise of $100 billion per annum by 2020 is still debated. Creative accounting has essentially conflated compatible finance flows related to Article 21C with commitments under Article 9. Furthermore, the special vulnerabilities and capacities of small and vulnerable states such as our SIDS have not been operationalised sufficiently. This is clearly evidenced in the minuscule access to climate finance for SIDS to date, in total receiving just 3% of that $100 billion promise, and only 0.22%, not even 1% for Pacific SIDS. The rate of climate finance flows is also pitifully slow, fragmented, and requires excessive specialised capacity to access. For Pacific SIDS, our experience in SBC as an accredited entity to the climate change financing mechanisms shows that it takes an average of 4 years and up to 6 years from project concept to project approval, and an additional 2 years just for the disbursement of those funds before implementation can even start. In simple terms, this means that from the time a community or a country requests assistance to the time they see actual outcomes, we are hitting the 8-year mark. By then, the need has changed, or it has significantly exacerbated. For context, based on current climate projections, the Pacific can expect to see sea levels rise 40 millimetres and experience 32 severe cyclones of Category 3 or above in that same time period. This is a blatant failure, a failure to deliver on clear finance-related obligations under the Convention and Agreement. It is a significant injustice for the most vulnerable, which remains largely without meaningful remedial measures. For example, there are still no special windows of access in the Green Climate Fund for Small Island Developing States, and it has taken 14 years since the establishment to finally have a SIDS dedicated officer under recruitment. And whilst we celebrated the establishment and operationalisation of the loss and damage funds at COP29 last month, let us remember that this has taken 30 years to come to fruition under the current climate change regime, and it is yet to be capitalised appropriately. Let me wrap up by being absolutely clear. Under no circumstances can we continue at this volume and rate of access to climate finance for small island developing states and LDCs and expect that they will be able to cope with the magnitude of impacts and loss and damage they are already experiencing, let alone what they are predicted to experience with increasing intensity and frequency of climate change-induced disasters into the future. This presents a blatant injustice to the rights of the most vulnerable, and certainly for future generations. And on this note, let me thank you for your time and hand over to the voice of a representative of these future generations. One of the critical responsibilities SBC is mandated to lead on is to empower Pacific youth in their aspirations for human rights and sustainable development. And for this reason, SBC is very proud to provide the rest of our time to the Pacific Island students who are fighting climate change, whose conviction for self-determination and survival in the face of climate change birthed the call for this critical advisory opinion. Mr. President, I kindly ask you to call their director, the Amazeballs, Mr. Vishal Prasad, so that you can hear directly from the youth that dreamed up this case. I thank you.
I thank Ms. Bazizi. I now give the floor to Mr. Vishal Prasad.
Mr. Madam Vice President, honorable members of the court. In the Pacific, we have always looked to the stars. Our ancestors navigated the vastness of the ocean and traveled immense distances. They trusted in the stars and wisdom of those who came before them. This practice, wayfinding, is more than just a method of navigation. It is a relationship. It connects those who came before with those who will follow. Every decision mattered, not only for the journey in that moment, but for the future that it shaped. Today, the world needs wayfinders, those who can guide us towards a path that protects our homes, upholds our rights, and preserves our dignity. I speak to you today as part of a global campaign led by young people and frontline communities, the Pacific Island students fighting climate change, who believe that international law must serve as a compass for justice and accountability. Yet ambiguities in its interpretation and application are hindering responses to the climate crisis, obstructing collective action, and threatening efforts to secure a just and equitable future. Our campaign for an ICJ advisory opinion was born out of a frustration with the inability of the COP processes to deliver urgent climate action. Recognizing that current efforts fall woefully short of what the world desperately needs, despite repeated warnings and overwhelming scientific evidence, even the most basic progress remains elusive. The Paris Agreement and the UNFCCC do not exist in isolation. Rather, they exist alongside a wide range of treaty and customary international law obligations. Obligations that have been and remain relevant to addressing the climate crisis, including the duty to prevent significant transboundary harm, the right to self-determination, and the human rights of present and future generations. Unfortunately, arguments have been brought before this court where some choose to hide behind their good faith obligations, shamefully content with pouring billions into a dying fossil fuel industry, an industry that continues to pump out planet-killing emissions causing significant harm, all while trying to evade accountability. Mr. President, I submit that this conduct that is driving the climate crisis is unlawful. The pursuit for climate justice requires determining the obligations of states, but is incomplete without the requisite legal consequences. For young people, the demand for reparations is crucial for justice. We have inherited a planet in decline and face the grim prospect of passing on an even more degraded world to future generations. Equally clear is the demand for immediate cessation. If greenhouse gas emissions are not stopped, we are not just risking our future, we are welcoming its demise. Mr. President and Madam Vice President, honorable members of the court, in referencing future generations, the argument has been made that international law need not protect abstract persons from abstract risk. This is a reasoning of convenience, and it is wrong. There is nothing abstract about human rights and the crisis that it causes. It is not abstract that climate change violates our fundamental human right to life. Lily Tiafa from Tuvalu recounts a harrowing experience of graves being unearthed by coastal erosion, and I quote, 9 years ago during Cyclone Pam on the island of Nui, I saw my 16-year-old cousin cuddling towards her mother's bones. I saw a mother cry out to the Moana, searching for the corpse of her son, end quote. It is not abstract that climate change violates our right to a clean, healthy, and sustainable environment. Isabella Tewea from Kiribati poignantly describes her reality, and I quote, the ocean, once a nurturing mother, has become a vengeful giant, swallowing the land it once cradled. It no longer gives life, it now takes it inch by inch. Where it once offered sustenance, it now brings destruction. Its rising tides are cold and unrelenting force that pulls homes, cultures, and futures into its depths, end quote. These are just a few examples of testimonies tied to the human rights impacted by climate change. Countless efforts, too numerous to list here, are detailed in the People's Petition. This was an outcome of the People's Assembly that we organized for frontline community representatives from around the world to speak of their reality, of the harms they have already suffered and continue to suffer because of the climate crisis. As you deliberate, you must hold these voices in mind. These testimonies recall great sadness, loss, and pain, but they should not be taken as a call for pity or favor. Instead, they are a united call for fairness and justice. As my colleague and friend Cynthia Honuhi said on the first day of these proceedings, it is not too late to course correct. This is why we turn to you, distinguished members of the court. Through this advisory opinion, you have the opportunity to help us course correct by holding those responsible for the climate crisis accountable, by reinforcing the importance of existing frameworks for liability and reparations, by ending emissions impunity and protecting human rights, ensuring that the legacy we leave behind is a legacy of resolve. Mr. President, Madam Vice President, honorable members of the court, 5 years ago, in a classroom in Amalus, Vanuatu, where this campaign began, young people dared to take on the impossible, taking climate change to the world's highest court. Today, we have completed that task. We have laid before this court our stories, our realities, the injustices and the loss, with the hope that this court understands all that is at risk. Just as the wayfinders of the Pacific held the wisdom to guide us through the vast ocean to safe harbor, you hold the knowledge and the responsibility to guide international community to ensure the protection of our collective future. And you can do this simply by applying international law to the conduct responsible for climate change. Vinakavakalevu, dhanyawad, and thank you.
I thank the representative of the Pacific community for their presentation. Before I invite the next delegation to take the floor, the court will observe a break of 10 minutes. The hearing is suspended.